Okay, I think most people are in. So good afternoon, everybody, and thank you for joining myself, Joanna Gillan, and Dr. Charlotte Proudman here today on what is otherwise an incredibly beautiful day outside. We are going to be talking to you about Schedule 1 of the Children Act. A few housekeeping issues first. These seminars, I'm told, are being recorded, and you can find the recording and these slides on the Goldsmiths Chambers website following this seminar. I can't hear you. If you're worried about that, I'm also promised that you're all muted on entry, so you don't have to worry about making any noise, and I don't believe you have a mute button if you were trying to find one, so please don't worry about that. Okay, so let's begin. What is Schedule 1? Schedule 1 to the Children Act was intended to make limited financial provision for the children of unmarried parents when they separated. This was followed by the Children's Support Act, and this means that the CSA has primary jurisdiction for assessing and enforcing child maintenance. But this has left the courts with residual powers for financial provision, and that's what we're going to be looking at today. Because the court has limited powers to make limited orders, these applications really only apply to a certain group of people. Generally speaking, they tend to be former partners of the wealthy or former cohabitees seeking a home during a child's minority. Again, this is simply because of the limited orders and their applicability to particular families. When you're talking to your client, it's going to be very difficult for you to predict what's going to happen in these cases. That is because they are dealt with on a case-by-case basis, and a lot of the case law that we find in these matters deals with very high net worth parties, so making predictions in mid-net worth cases is very difficult. What that means is that these cases are a fantastic idea, or it's a fantastic idea in these cases to mediate and to negotiate before making that application, and indeed during the course of the proceedings. Also, Dr. Proudman will be talking about costs as well, which is another consideration that you're going to want to think about with your client. The types of orders you can make, we're going to deal with these in a little more detail in due course, but they can be summarized as follows: housing, lump sum orders, or periodical payments. Periodical payments, again, can be broken down into 2 or 3 categories. The third you don't find on this screen is when you're dealing with education, where there is a disability with any of the children, but also where you are making an application for a top-up order. And those are in cases where the non-resident parent's income exceeds 156,000 gross or 104 net each year, and the court is satisfied that it's appropriate to make an order. Things you're also going to want to consider. You're also going to want to look into whether the parties that you're dealing with have agreed a child maintenance order where there's no calculation in effect, then the court will have jurisdiction, or cases where the CMS can't get involved because of a non-party's or a party's non-habitual residence within the UK. You're also going to want to take account of any stepchildren, children over 18 who are still in education, or over 18s that are making their own application. Remember that the court has jurisdiction over an 18-year-old if the application was made before they turned 18 in their minority. There's a very interesting case here, which I know Dr. Proudman will be looking at later on, but that's going to be something that you'll want to look at to update yourself, as that is 2020 decision. But I'll leave that there for now. The procedure for making an application is set out on this slide, and very briefly you're going to be looking at A1s and A's to make these applications, and E1s and E2s for disclosure within these proceedings. Schedule 1 is a financial remedy as defined by the family procedure rules. You're also going to want to look at the pre-action protocol. Mediation, again, really important to think about mediation in these matters and settling outside of court, and also the fast track procedure where appropriate. The considerations are very similar to the Section 25 checklist, but rather confusingly and consistent with a lot of the law that we find in family matters, there is no specific provision to the welfare of the child, but we have a case, Re P, that says that it's a constant influence. Furthermore, there's no reference to standard of living, but we have a case, FVG in 2004, where Judge Singer reminds us that in appropriate cases, the standard of living may be the dominant feature. Another interesting case is AVA, a rather old case, interesting because the mother lied about the children's parentage and it was considered not a relevant consideration because conduct is not something that is regarded in these matters as very high on the list of considerations to be taken by the judge. Now I'm going to pass over to Charlotte to talk to you in a little more detail about the orders the court can make.
Thank you, Jo. So I'm going to move on now to speaking to you about orders relating to housing. So perhaps your client may wish to apply for an order requiring a settlement or transfer of property for the benefit of the child. And that's really a key consideration, that it does need to be for the benefit of a child. The court has a wide range of powers, which can include the power to transfer a joint tenancy, for example. Now, interestingly, in a case here, which you'll see of A&A, which is a 94 case, Ward J observed that Schedule 1 gave an adult child the ability to apply for a periodical payment order or a lump sum order, but not a settlement or transfer of property. He went on to say that restriction serves to confirm that property adjustment orders should not ordinarily be made to provide benefits for the child after he has attained his independence. So the idea being that once a child attains the age of 18 or over, they can apply for periodical payments or lump sum, but not necessarily property. The idea being that the child should be independent to make arrangements for their living in the longer term. However, it does go on to say, unless there are exceptional circumstances, and that becomes relevant in the case that Jo mentioned a moment ago with DN and UD. Now, this is a case before Mr. Justice Williams, who made an outright capital provision for the benefit of the children, and it was quite a significant sum of £650,000 each to purchase homes for them as adults. Now, the children were aged 17 and 12 when the mother applied for periodical payments and lump sum orders. That's important because the mother was applying on behalf of the children at that stage. When the final hearing took place, one of the children had already attained the age of 19 and was an adult, but the judge took the view that provided an application was made before the child attained 18, then the court could retain jurisdiction to make such orders, including capital provision orders by way of such lump sum that they can purchase a property in their own name. And that the court retains that jurisdiction until the disposal of the application, even if such orders are made for the first time after the child attains the age of 18. So it's a question really if you're seeking that transfer of property or a settlement for property, to make that application while the child is under the age of 18, which makes it a lot more straightforward. But it nevertheless may mean that still the court may not make a property adjustment order on the basis that the child, by the time they're that age, should have reached independence. So it's often a balancing exercise, and as Jo said, a case-by-case basis. Now, lump sum orders is a common order that we see applied for under Schedule 1 applications, and in such a case, the applicant can apply at any time and on any number of occasions for a lump sum order. And it's lump sum order is not limited to, but can be made to pay liabilities or expenses as long as it relates to the child. So, for example, maintenance or incurred with the connection of the child, or reasonably incurred before the making of the order. So, for example, that might give rise to liabilities. The court can still take that into account. A lump sum order can be ordered to be paid in instalments. It doesn't have to be paid in one final sum. And it can be paid in a sum payment. At the same time as ordering lump sum payments, the court can make a charging order to secure payment of the same. So what that would mean is that if there were concerns that perhaps that lump sum may not be paid, but perhaps one of the parents owns a property, then the charging order can be put on that property to make sure that that payment does come to fruition. So that may be required if you have a particularly difficult parent who you may think may not comply with that order to provide for a lump sum. Now, periodical payments are orders that Jo and I often see being applied for, and in fact these are often the most common orders which are applied for, unless you have a high net worth client or individual such that they have sufficient money available to purchase a property or give a lump sum. But in most cases it's periodical payments. Now, the court has jurisdiction where the CMS does not have jurisdiction. So, for example, as Jo mentioned, it could include stepchildren, provided the parents were married. and there is no jurisdiction to make orders in favour of another person's child where the parties are not married. It can also include, for example, making an order for children over the age of 20, whilst they remain in education, or where there are special circumstances. For example, if a child is disabled, or that education is going on for a prolonged period of time, perhaps due to exceptional circumstances such as mental health or other issues. The CMS doesn't have jurisdiction, but under Schedule 1 the court does. Now, applications to the court permitted by CMS or the CSA Act, the court has jurisdiction still to make the following orders for periodical payments, and that's still permitted by the CSA Act. So even though orders can be made for child maintenance, nevertheless, the court can still entertain applications under Schedule 1. For example, exceptional cases of educational expenses, if your child goes to a private school or there are further fees incurred, CMS can't accommodate for that, but fortunately the courts can under Schedule 1. And as I mentioned, costs attributable to a disability, for example, running a car or additional help or respite care. In addition, top-up orders, we see these often with high net worth individuals where CMS may make a calculation, but it's just simply not enough to live the continuous luxurious lifestyle that the family have grown accustomed to. And in those circumstances, one can apply for this top-up order. And it sets out the circumstances for that, again, mainly on a case-by-case basis. Periodical payments orders may begin from the date of the application. So even if that application takes a year, 2 years, the court can backdate any payments that ought to be made following a final judgment. If a CMS application ceases to have effect and an application is made to the court within 6 months, the term of the order may commence on the date that the former calculation ceased. So again, that just makes clear that it can be backdated. The order ordinarily does not extend beyond a child's 17th birthday unless the court thinks it's right in the circumstances for the order to be made longer. And I just want to make very clear that when a child is of adult age, the child needs to make that application under Schedule 1. The parent must not make it. And I dealt with a case where the mother incorrectly applied under Schedule 1. The child didn't make that application. And by that point, the child was of quite a significant age by the time it got onto court. So the child couldn't even make that application, and the child had already ceased training, vocational training. So in those circumstances, I was for the father, and we got the application struck out, and the mother then had to pay costs, and they were fairly hefty costs as well. So, and unfortunately, her solicitors and counsel didn't advise her not to make that application given the child's age. Now, interference with Talati, it's important to be aware of the difference between Schedule 1 and Talati claims, and Jo is going to explain a little bit about that.
Thank you. Well, it's exactly that. You just need to be aware that these cases often run together because of what the parties are applying for. So an unmarried couple will be looking to have the court define the particular share they have in the property before making a Schedule 1 application, which may mean that some of the other party's share is provided for the benefit of the child. But they are completely different matters with completely different practice directions, bundles, different judges, and different procedures. So when you're dealing with these types of cases, you have to be really aware of those. The court will generally help you understand what the lead case is. Because of the different results you can get from each of these matters, generally speaking, the Talati matter will need to be dealt with first, so that the amounts apportioned to each party can be decided before the Schedule 1 matter is dealt with. But again, looking at these slides, you just have to be aware of the difference in the applications and how the courts may deal with that. Silly things like, for example, the Schedule 1 matter will be private, the Talati matter will not be private.
And just to touch on that point that Jo has very helpfully mentioned, there can often be an overlap between Schedule 1 applications and private law children applications for child arrangements. So in another case that I dealt with where the mother had applied for a variation of the child arrangements order and had also sought for the father to continue paying the private school fees for the children. So had made a Schedule 1 application to continue paying those private school fees. And the father had then cross-applied for a specific issue order to take the children out of private school and put them into a state school. So for the judge, it was important that the Schedule 1 application was determined before the specific issue order application was heard, because the court couldn't make a decision whether the father had to continue paying those school fees, and only he could afford, before the court could then decide whether the children should go to a state school or not. So sometimes there can be an overlap between Children Act proceedings and Schedule 1. Now, in terms of costs, the general rule for Children Act applications is that there's no order as to cost, but unfortunately that doesn't apply in Schedule 1 proceedings, as I mentioned a moment ago. We've seen cases where there has been a significant cost order having applied as a result of one party being unsuccessful. So it could mean that you're ordered to pay the other party's costs in some circumstances, particularly where in one case, as I mentioned, the party erroneously applied, the mother applied instead of the child over the age of adulthood. Now, interim lump sum orders can be made for funding legal costs. So we see in divorce proceedings, LASPO applications being made, which means that then the other side will pay your client's costs if your client can't afford, and there's a legal test for that. In Schedule 1 applications, we have a similar provision where the court does not have jurisdiction to make periodical, where the court does not have jurisdiction to make periodical payments. The fact that any number of lump sum orders can be made at any time has been used to allow a party an interim lump sum to pay for legal costs. So rather than making a periodical payment to pay legal costs, the court instead has jurisdiction to deal with interim lump sum payments to meet those costs if that's required. The court had no jurisdiction to make a periodical payments order, so again it made a lump sum order to cover the mother's legal costs in CF in KM 2010, a High Court decision.
Thank you very much, and thank you, Charlotte. I promise it wasn't on purpose, but I erred in not telling you at the beginning of this talk that you can ask us any questions by typing into the button that I hope you can see at the bottom of your screen marked Q&A. There is also, I believe, a comment section. It's going to help me greatly if you put any questions in the Q&A, because that's a button I can see on my screen. Otherwise, I'm going to have to investigate, and you may get a picture of my children or my dog if I start closing different screens. But do ask any questions. We have some time now to answer if you have any from the Q&A box. I don't know, Charlotte, if you can see any comments there on your screen.
Not at this stage. There are no open questions, but I'm sure.
But we have a taker. Would the court have any jurisdiction if there is already an overseas divorce proceeding and financial proceedings? Charlotte, I don't know if you can help with that question. So would the court here have jurisdiction?
Yeah, that's a very good question to ask. I mean, ordinarily when there are divorce proceedings and financial proceedings ongoing, then the courts would have jurisdiction within financial proceedings to hear any applications that you might make for the benefit of the child. So, for example, if you're seeking periodical payments for the benefit of the child, or you may be seeking maintenance pending suit application if one party is particularly struggling to meet their maintenance costs on an ongoing basis. So ordinarily, that's the correct route that would be followed, because under the Matrimonial Causes Act, there is sufficient provision there for the court to make a range of orders, often a lot more broad than under Schedule 1. And also, you wouldn't necessarily have the costs as well, the cost issue.
Thank you, Charlotte. I can see that there's a, we have a thank you. I can see that there's a comment in the comment box. Charlotte, can you see that question there?
Where the non-resident parent lives abroad, is the maintenance which must be paid by the non-resident parent limited? I think that should be to what the CMS will order. So again, where the non-resident parent lives abroad, is the maintenance that must be paid by the non-resident parent limited to what CMS will order. So in terms of Schedule 1, as we try to illustrate, Schedule 1 applications are not limited and bound by what CMS calculate as the correct maintenance payment. So regardless of whether one parent is living abroad or living in this jurisdiction, it really doesn't make a big difference. The question that the court will look at under Schedule 1 is, what are the needs of this particular child or the resident parent who's caring for the child? And have those needs been met with a CMS application, or perhaps the needs are greater? And then the court will look at whether they can accommodate that. So no is the short answer. The court will not be bound or will solely look at CMS.
I think that goes a little bit towards what we were saying earlier about it being very difficult to predict these cases. The prediction that you can't make is what award you're going to get, because there is no calculation, much like with the CMS. These are dealt with on a case-by-case basis, taking into consideration the means of the parties and the particular needs of that child, taking into account things like the standard of living and other surrounding circumstances. So it makes it a really tricky matter to predict the type of award you're going to get, unlike with CMS, where there's sort of a mathematical equation that they'll be looking at to come up with their monthly award. So, so Charlotte said no. Any further questions? I should say, I'll say it again, these slides together with this recording are going to be on our website. So hopefully I'll take the lack of questions as a good indication that we've dealt with everything you could possibly want to know about Schedule 1 applications. But if something comes to mind later on, of course, you can contact us. There are some contact details on your screen now.
We have one more question, follow-up question from the one that I mentioned earlier. If the parents were married and the non-resident parent lives abroad, then is the maintenance limited to what the CMS will order? So if the parents were married and the non-resident parent lives abroad, then is the maintenance limited to what the CMS will order? Jo? No. I think, again, it's a short answer. It's a similar answer to the one we've given. That wouldn't make a difference. Yes, I think that's right. Just to confirm that there is no calculation under Schedule 1.
That's the point, yeah.
In terms of a discrete calculation of there are so many assets or financial resources available, and this is what the need of the child is, and therefore this is the formula. The courts will take a broad brush approach and look at all of the resources and all of the needs, look at what CMS may or may not say, and then make its own calculation.
You're almost putting CMS, once you're dealing with Schedule 1, you're putting CMS completely to one side, and you can forget about that. Schedule 1 is its own little ballpark.
We have one more question. Are educational costs orders made for a limited time, or can it be extended if, for instance, the child is expected to go for a master's degree? And the answer is yes. Yes. One can apply for educational costs that are incurred over an extended period of time. But I think just to keep costs on the low side, my advice would be to make one application before the child commences university, if that's the correct time. In fact, I represented a child in a very similar case where she was undertaking a 4-year course which included a master's, and she was very adamant that she wanted to do a master's. And so what she was seeking was an award which met some of her educational costs, her living costs for that 4-year duration. And the court granted her a limited sum of money each week to be paid for by the father. Just to confirm again to all those that are listening and with us today, the slides will be put on our website, and you can also receive a recording. So that's to Tariq, who has just sent a message to say, can we please email you the slides? In fact, you can go onto our website and view those at your leisure.
And just going on again from what Charlotte said in answer to that question, it is an interesting case to read in full if you had the time. I'm sure you'll want to go outside and sunbathe instead, but later on in the day, if you want to read the recent decision, 2020 decision on exceptional circumstances that meant there was a larger reward than otherwise there would have been, then please do read that, because it is a good read and it sets out the basic law as well that allowed the judge to get to his final decision. So that'll help you with those matters.
It's a fascinating read and suggested bedtime reading for all of you.
Absolutely, when the sun goes down. Okay, well, Charlotte, unless you can see any further questions, I propose to close there, but thank you everyone for joining us today, and thank you, Charlotte, and we hope to see you at the further talks that Goldsmith Chambers is providing, that can be found, I believe, on our website if you are interested in those.
And may I say, if there are any talks or any topics that you would like to hear, please do get in touch. Our email address in terms of our clerks, Alex Nunn and Scarlett Watkins, are below on this slide. Please do send an email and we will take that into account. There is just one final question before we round off. Can you get payments made by child arrangements order for extended members of the family, say grandparents? No, is the answer for that, no. The payments are for the child, as I mentioned earlier. So if the grandparents are caring for that child, then that would be different because it would again be for the benefit of the child. Jo, I'm not sure if there's anything else you want to add.
No, that covers that. And again, there's no questions here in the Q&A that I can see. So thank you very much, everybody. And I shall close the meeting there.